It's been a long time, but my time is finally near, and I can feel a change in the wind right now. Nothing's in my way, and they're not gonna hold me down no more. No, they're not gonna hold me down, 'cause I've got faith.
I'd like to have our keynote address from our Washington State Attorney General, Rob McKenna. Rob himself is a previous recipient of the Key Award for his strong support for principles of open government, and the fact that every year that he has been serving as our Attorney General has made strong proposals to the legislature to strengthen our open government laws. It's a pleasure for us to have him with us today, so please join me in welcoming Rob McKenna.
That's better. I like that. That's good. It's just a little odd that the giant picture of that floating back there. Well, congratulations, Toby, and to you, board members of the Washington Coalition for Open Government. What a tremendous success. You always know your conference is going to be successful, and you have to move it to a bigger room to accommodate the large number of people who have RSVP'd. So congratulations to the Coalition. Moreover, thanks to all of you for taking the time out on this glorious Saturday morning to come down and to be part of an effort that effectively tries to clear away the fog around government and its public records by being champions yourselves for these issues. As I look around this room, I see many people who have been themselves leaders on this issue, who have been strong enough to stand up and demand accountability and have exercised their rights under the public records in local government and state government all across the state. So it is good to see so many old friends and acquaintances here, and thank you very, very much for taking the time. I want to deliver a report on public records issues as they involve the Attorney General's Office, in particular legislation that we've been working on. It has been a very busy 5+ years. I'm in now my 6th legislative session that's occurred since I've been Attorney General, and for the 6th year in a row, we have introduced important legislation to strengthen our state's public records regime. I'm going to give you a little bit of history of what we've already accomplished, some successes and some failures, and I'll talk about a very important piece of legislation that we have introduced this year jointly with State Auditor Brian Sontag in partnership with House Majority Leader Lynn Kessler. I'm also going to report on an important decision that was reached yesterday by the highest court in the land that I think you'll be interested in, and some of you might already be aware of. I began working on these issues as a brand new Attorney General in 2005. One of my campaign pledges in the 2004 campaign had been to try to address damage that was done to the public records law by the state Supreme Court's decision in a case called Handgartner. Many of you will recall this case. It's actually a consolidated case involving Sound Transit and the Monorail Authority. And in that case, the Supreme Court reached some unprecedented conclusions. For example, they concluded that you're allowed to, as a member of the public, request public records, but you're not allowed to request too many public records. They didn't tell you how many is too many, so it was up to you under their ruling to guess what the right number was. And if you went to the agency and they said, sorry, this is too many, then you had to go back and reformulate your request and come back, and then they could say, yes, this is okay, or no, it's still too many. The point was that the Supreme Court made up a rule that could not be found or supported in statute, as far as I was concerned, and in any event was really bad public policy, since the whole point of public records is they're public, and therefore whether someone asks for a large number or a small number, they're entitled to have them. There were other problems in that ruling as well. For example, the ruling opened the door to the much wider use of the attorney-client privilege by public agencies to block requests. Essentially, any aspect of the attorney-client privilege could be cited as a basis for denying a public records request. This caused me to be very concerned that it would result in agencies bringing lawyers in at every opportunity so they could later claim that a public records request could be denied based on attorney-client privilege. I said at the time that I thought it could result in lawyers being turned into potted plants. You just have one in the room all the time. so that you could then later claim that the records that came out of that meeting, whether it was the minutes or notes or other records, could be barred from disclosure. We went to work on that and other aspects of the Handgartner case in our legislation in 2005. And I think it's significant that the very first bill of the many dozens of bills I've requested of the legislature over the years was a bill to strengthen the public records law. And that bill was aimed squarely at some of the, all of the provisions that we disagreed with in Handgartner. And we got about 70% of what we wanted. We didn't succeed in persuading the legislature to change or to clarify the rules on the use of the attorney-client privilege. In fact, one state senator actually introduced an amendment to our bill that would have codified Handgartner's ruling with respect to the attorney-client privilege. So we ended up asking that language, the language we had offered, be taken out of the bill so it could not be amended in a way that all of us would dislike. But we did succeed in overturning other aspects of the Handgartner decision by statute, thanks to the support of then State Representative Toby Nixon and other champions of open government like Lynn Kessler. And in particular, we persuaded the legislature to adopt language that made it clear that an agency cannot reject a request because it is for too many public records. So aspects of the Handgartner decision that we didn't like were undone by the legislature, which is, after all, where this kind of public policy should be made. 2005 was also a watershed year for our office in other respects with regard to public records. It was that year that I announced the formation of creation of a position in our office called the Assistant Attorney General for Government Accountability. It was a position initially held by Greg Overstreet, who's now in private practice, and is now held by Tim Ford. I'm guessing that many of you have interacted with Greg or Tim and have utilized their services as informal mediators of public records disputes. They have been able to, together, over the last 5+ years, have been able to help successfully resolve dozens and dozens of disputes between requesters and agencies, typically by asking an agency, after explaining what the law is to them, to comply with the request. So there have been many requesters who have been able to obtain records they had asked for without having to hire a lawyer and go into court, because we've been able to intervene and explain to the agency without a lot of fanfare, just plainly and simply, what the law is. It was also that position that was responsible for creating the model rules under the Public Records Act, a project we undertook in 2005 that Greg Overstreet deserves a great deal of credit for. Our idea was very simple. It was that everybody would be better off if we had a set of model rules that helped illustrate, illuminate, and implement the Public Records Act. You know, there are many statutes for which there are rules in the Washington Administrative Code that help explicate that statute and help fill in the details. And that's what we were seeking to do with the model rules. In order to develop the best set of rules possible, we went on a statewide tour of cities in Washington and partnering with major newspapers in each of those cities, for example, the Seattle Times here in King County. We held a series of public forums on open government, focusing on what people would like to see included in those model rules under the Public Records Act. And after about a dozen meetings on a tour that I think Greg dubbed Public Records Palooza, we had collected a great deal of input, and we were able to produce another draft of the model rules and to finalize those with broad input and to put those into place. The model rules, which are incorporated into the Washington Administrative Code, are available online, and they serve as a useful guide for agencies and for requesters, because we took input from agencies and requesters with regard to what areas of the law they needed to have clarified. We also helped write the desk book for lawyers under the Public Records Act. Again, Greg deserves a lot of credit because he was the editor. And that desk book serves as a very handy reference source for lawyers who are seeking to properly apply the Public Records Act. So 2005 was a big year, and I think if you had to sum it up, what it really represented was the first instance in our state's history where the Attorney General and the Attorney General's office stepped up to become an advocate for and an enforcer of the public records law generally written. It doesn't mean we still don't have to defend our clients if there's a public records dispute. Of course, we do that, sometimes successfully, sometimes We can't save the clients from themselves. The point is that our job is, in my view, not just to represent agencies, but also to be a forceful advocate for our sunshine laws, for transparency and for accountability, including the public records law. We continue those efforts in subsequent legislative sessions. For example, in 2007, we had 4 bills that we offered to the legislature. Again, we had strong support from state legislators, a strong interest in these bills, and these 4 bills were all adopted by the state legislature. One of them restored voter-approved intent language to the Public Records Act that had been inadvertently deleted by the legislature when they had adopted our bill in 2005. A second clarified the statute of limitations for lawsuits alleging a public records disclosure violation. A third established a law that most other states already have that we didn't, and that was the Reporter Shield Law. The idea is that a reporter should be protected from becoming a source, for example, a source of discovery in civil litigation by independent litigants who decide it would be very handy to have the reporter's notes or unused videotape or audio tape. We believe, I believe, and I know the coalition agrees, that the role of the media in our society in assuring accountability is extremely important. It is investigative reports by Eric Nalder, for example, who's here with us today, and some of his colleagues at the Seattle Times that have been so important to helping to correct problems in government. For example, the fact that coaches were being shuttled around from school district to school district after being accused of abusing students with no access to the public records frequently being offered to the public. Investigative journalism plays a very, very important role in our society. It's not by accident that we consider the media the unofficial 4th branch of government, because they are our most important resource as citizens to keep tabs on what government is doing. But in Washington State, other than a couple of Superior Court cases which upheld the right of media outlets to protect their work product from disclosure, we didn't have a law in place. So after a lot of effort and a great deal of collaboration between the Coalition for Open Government, attorneys for some of the newspapers in my office, we crafted a piece of legislation that was finally adopted by the state legislature and has been a success. Subsequently, the federal government, I don't know if Congress finally adopted the Federal Reporter Shield Law.
No, the final language is out of committee and ready to go on the floor.
So it's taken all these years to finally get a federal bill to the floor, but I have provided strong support to that federal legislation also to provide protection for reporters and their work product. We also persuaded the legislature to adopt a bill in 2007 creating what we informally refer to as the Sunshine Committee. The basis for the Sunshine Committee came from my observation and that of others that in the 30-plus years since the Public Records Act was adopted by initiative, an act which started with only 10 exemptions to public records disclosure, that around 300 additional exemptions have been created by the legislature, often without a great deal of thought. We saw an increasing practice of including exemptions from public disclosure in bills that were being introduced to the legislature. In fact, at one point, I think it was in the 2000 legislative session, we counted 28 separate bills which, as a feature of those bills, would have created a new exemption from public disclosure of some sort. So the legislature had gotten into the habit of routinely creating exemptions from public disclosure when they were adopting legislation about other topics. The Sunshine Committee is charged with the responsibility, since it was enacted by the legislature and signed into law by the governor, of reviewing those 300-plus exemptions and making recommendations to the state legislature for amendments or even abolishment of some of those exemptions. They have found it is hard work because they've discovered that every exemption seems to have a constituency. Some group or individual who wants to protect against disclosure. So this means that the Coalition for Open Government and all of you and all of us who care about public records and access to government need to be, I think, number one, vigilant to guard against new exemptions being created that are unwarranted. And number two, we need to provide support to the work of the Sunshine Committee. They have made several recommendations to the legislature which have thus far not been enacted. So it turns out that once these exemptions get cemented into place, it is not easy to break them loose The Sunshine Committee is one tool for doing that, and they've been doing some good work. Unfortunately, the governor has proposed abolishing it, or at least abolishing the funding for it. I'm here to tell you that even if the legislature cuts the very modest amount of funding that is devoted to this effort, it's less than $100,000 a year, in fact, far less than $100,000 a year. Even if that happens, I am committed, and Auditor Sontag is committed to make sure the Sunshine Committee continues to operate. We will do what it takes to keep it going. In the 2009 legislative session, we brought forward a proposal that was the product of collaboration among advocates for disclosure, also with government agencies, but all of us working together to try to improve the system to everybody's benefit. And what we were aiming at in that bill in particular was to address a real and current threat to the public records, and that was the threat of a handful, and I want to stress it has been a handful of inmates in the correctional system who have turned public records requests into a cottage industry because, as one of them put it, you can make a lot of money doing this, he discovered. And the threat that this poses is quite simple. First of all, it clogs up the system so that legitimate requests, for example, by other inmates who are seeking records related to their incarceration and their convictions, are held up while thousands and thousands of requests coming from 5 or 6 inmates work their way through the system. Number two, some of these inmates were making these requests for the evident desire to harass and intimidate their correctional officers, local law enforcement, people in my office, government officials around the state. One of them made it very clear that he was making these hundreds and hundreds of requests because he was trying to put pressure on corrections to transfer him from one prison to another. So our goal was to draft a piece of legislation that would protect the rights of all inmates to request records, but provide an avenue for blocking requests that a judge concludes, beyond reasonable doubt, were made for the purpose of harassment and intimidation. And that law was adopted by the state legislature in 2009, has taken effect, and has been used just a couple of times since it was enacted, but has been used effectively to stop, in particular, a couple of inmates who were making thousands of requests, and were making requests that had absolutely nothing to do with their own cases, but had a lot to do with their desire to play a game of gotcha with agencies in order to collect the penalties and the fines. So that's an example of an improvement to the law which helps us separate the handful of bad faith requests that are made from the overwhelming number of good faith requests that are made, including requests of the type that many of you have made over the years. And we were happy in part because it was the first time we were able to get everybody who's interested in public records, requesters, agencies, lawyers, everyone around the table, to come up with a proposal that improves the system for everybody. We were less successful with a piece of legislation in 2007 and 2008 regarding public meetings. In those two sessions, 2 times in a row, Auditor Sontag and I, again working with Majority Leader Lynn Kessler, introduced legislation to try to reduce abuse of executive session by elected bodies such as city councils, county councils, fire district commissioners, and so forth. The problem is that Auditor Sontag had noted over 400 instances in which there were serious questions raised about the way executive session was used. Executive session, the idea that you can close the doors and kick out the public and then conduct the business of that government body, is supposed to be used very, very sparingly. But instead, what the auditor has noted is that it is used more and more, and he has documented in just one 3-year period about 400 concerns, some small, some big, concerning the use of executive session. So our concept was very straightforward. It was the idea that executive sessions should be recorded, for the simple reason that if there's a dispute afterwards about whether the executive session was proper or not, it could be reviewed, the tape could be reviewed by a judge behind closed doors to determine whether or not it was proper. If it was improper, then the judge could take the appropriate action. If it was proper, then the information could continue to be kept confidential, but the judge would have been able to make that determination. Well, you would have thought that we were planning to burn down City Hall by the reaction that we received to that legislation. It was, to put it mildly, hostile. And one of the facts at Olympia that this legislation really helped me appreciate is that there is no larger group of lobbyists in Olympia than the lobbyists who work for local government. There are more lobbyists working for cities, counties, special purpose districts, ports, hospital districts, you name it, than any other type of lobbyist in Olympia. And they descended on this bill like a plague of locusts and did manage to bottle it up in committee. They complained, or the people they represented complained, that we had not adequately consulted with them in drafting that bill. So Auditor Sontag and I said, fine. We sat down, and for several months between the 2008 and 2009, or between the 2007 and 2008 legislative sessions, we worked with them to craft a bill that they said that they could live with, that we thought would still achieve the basic aims that we had. And in particular, we agreed to a compromise which said that executive sessions would not have to be recorded in every instance, but upon a finding by the court that an agency had abused executive session, they would then be ordered to start recording all of their executive sessions for a specified period of time. In other words, we would focus that remedy on those who had been found to have violated the Open Public Meetings Act, zeroing in on the problem agencies. And the local government representatives that we had negotiated in good faith for several months said, yes, this is fine, we're okay with this, and they agreed to the mandatory training provisions for public records and public meetings laws that we included in the bill. We thought we had it all ironed out. But then some number of their lobbyists who have yet to come forward and admit that it was them, worked behind closed doors and stopped that bill as well. So that was frustrating, and it shows that while we've made a lot of progress, we haven't been 100% successful. But I can tell you this, it has not reduced in the least the determination that Auditor Sontag, Reed Kessler, legislators and former legislators like Toby Nixon and I all share to continue looking for ways to strengthen our Public Records Law and our Public Meetings Act as well. This year, we have a piece of legislation that has very broad support. It's supported by members of both parties, by leaders in the House and the Senate, by the governor, to create a new mechanism that we think will benefit everybody. And this is another bill that we put together with the broadest possible input, including members of the Coalition for Open Government, representatives of state and local agencies, their attorneys, and others. The idea behind this bill came to me about 3 years ago, and it occurred to me that public records is one of the few areas of law for which there is no administrative mechanism to resolve disputes. So think a minute about environmental law, for example. When you go through a permitting process or you're working with an environmental law, there's an administrative process you go through first before you have to go to court. That's true for many other areas of law as well, such as workers' compensation law. But there's no administrative mechanism for public records disputes. Therefore, if you're an unhappy requester, you really have no option to enforce your rights short of hiring an attorney and going to court. I mean, of course, we try to help. If you contact us, we try to mediate, but we're merely advisory in the role that we play in our Ombudsman's office and in the Attorney General's office. So there's no administrative mechanism as there is in most other areas of law. So I started looking around and quickly determined, with Tim Ford's help, that there are several states that have an administrative mechanism that allows for the administrative determination of public records disputes in those states. And I proposed to Brian Sontag that we form a task force to look at what such a mechanism might be like here in Washington State. What should it look like? And again, we put together a very wide body of representatives of all the different points of view, sat them down, and remarkably, in just 2 meetings, this diverse group of people and agencies interested in public records issues came up with a consensus proposal for creating an administrative mechanism, basically an ongoing body that can address public records issues and disputes. It's called, or would be called, the Office of Open Government. And although it sounds like we're creating a new agency, what we're actually recommending is that a new function be established within an existing agency, the Office of Administrative Hearings, which has expertise in administrative law, which whose resources could easily be leveraged without creating a lot of new bureaucracy, in order to provide relief for people and for agencies that have concerns about particular public records requests. It would provide a speedy and inexpensive administrative appeals process that anyone can take advantage of with a lawyer or easily without a lawyer if they choose. They can just go on their own, much in the same way that you can go to the Public Disclosure Commission today with a complaint under our state's campaign finance laws and public disclosure laws. The idea is that a handful of additional people will be put in place at the Office of Administrative Hearings to hear complaints and concerns about public records requests, either from the requester or from the agency. They would be required to review and rule on those disputes within 30 days. They would also be available to issue advisory opinions interpreting our public records laws to provide greater clarity on agency duties and on requester responsibilities. They would submit an annual report to the legislature on their activities and recommend legislative reforms, so that even if the Sunshine Committee were done away with, we'd still have a body, a permanent body, acting in that similar role. They would also provide periodic training that would be mandatory for all elected officials and other designated agency officials, and would make training materials available for free on their website. Now, my office provides training and provides materials, but my concern and the auditor's concern is that that will only last potentially as long as I'm Attorney General. We want this set of practices and best practices to remain in place. And creating this function in this existing Office of State Government would be a sensible and effective way of accomplishing that. Now, there is a fiscal impact from this bill, and in a very, very difficult budget year, we don't expect the bill to be adopted this time, in this short session. But we wanted to get this bill out there to start engaging the legislature in a discussion. We had 4 legislators serve on the task force who were enthusiastic about it, and we look forward to moving it ahead and again in the 2010 session, or 2011 session, where it can be adopted and put into law when the state budget is in better shape. We're talking about a modest request, of some hundreds of thousands of dollars, but a great benefit, we think, to everybody concerned. It's a win-win situation, a win-win proposal for all who are concerned about a healthy and robust public records regime in Washington State. Let me close by just making a comment on the Supreme Court's decision yesterday to grant certiorari in the Doe v. Reed case. Doe v. Reed is the case involving whether or not the names on petitions for initiative and referenda are a matter of public record. It comes out of the Referendum 71 case last year. And one of the main points I want to make to you about this is to correct a misconception about the case. The R71 sponsors claim this is about preventing harassment and intimidation of people who signed the petitions for Referendum 71. Fortunately, we can actually look to see whether or not that's a real concern, because the donor information, those people who donated to the cause to collect signatures for R71, those people who donated money for the campaign for R71 to support rejection of the law that R71 was challenging, that's all been a matter of public record since they made their donations. And as far as I know, there have been no reports of harassment or intimidation of any of the donors to that campaign. However, the judge in this case at the Federal District Court, Judge Settle in Western District of Washington Federal District Court, never reached those issues of harassment or intimidation. He never addressed the claims that releasing these names might result in harassment and intimidation. Instead, Judge Settle ruled categorically that all names on all initiatives and referenda, future and past, are exempt from disclosure as anonymous political speech, which is a term of art meaning speech which should be protected. For example, when you cast a ballot, that's protected. It's a secret ballot, and the government isn't allowed to know who you voted for. Judge Settle reached a similar conclusion about the names of people who chose to sign initiatives and referendum petitions. We believe that's not only wrong as a matter of state law and the public records law, it also is a misapplication of basic constitutional principles. The fact is that signing a petition to make a law, whether it's an initiative or a referendum, is effectively substituting oneself for a legislator. We don't legislate in the dark in this state. We legislate out in the open. And people who sign petitions must understand that this is not a confidential process. From the moment they meet that signature gatherer in the Walmart parking lot and fill out their name, fill out the form, and see all the other people's names who signed the petitions. And from the moment that signature gatherer turns that petition over to the campaign, which will routinely photocopy the petition and put all the names into its own database before turning it into the Secretary of State, no one should believe this has ever been intended to be a confidential process. And the problem with Judge Settle's opinion is he's saying that none of the names on any initiative or referendum can ever be public. We just think that's wrong. The Ninth Circuit agreed with our position and unanimously overturned Judge Settle. And although I don't always agree with the Ninth Circuit, I think they got it right in this case, and we look forward to going to the U.S. Supreme Court and successfully defending the Ninth Circuit's ruling and the position of the state in defense of transparency, accountability, and open government. Thank you very, very much.
Question. I don't know if you've ever answered this, and don't worry, I do a lot of research before I do an interview, but what made you decide to commit to open government causes like this?
Well, it comes out of my philosophy of government, which is that government which is open and transparent and accountable is the most effective. And, you look at governments that have problems of corruption, are ineffective, typically they're the most closed, whereas governments that have low levels of corruption that are more effective are typically those that are more open and accountable to the people to whom they're responsible. So I think it's a matter of good government, and it's an important aspect of the system of checks and balances that Madison and the other founding fathers were attempting to create from the beginning in our country with the Constitution.
Great. And question number 2, out of free. What do you think about some kind of model rules for public meetings, like public comment and that sort, so everyone knows what the rules are?
Yeah, I would support adoption of settled model rules. We think the model rules for the Public Records Act have been successful. They're useful to requesters and to agencies, and I think the same advantages would be found with public meetings.
Good. And finally, what do you think about having agencies record their meetings on audio device or video?
Well, I think it's a good practice for all agencies to record their meetings. They can do so now, of course, for open meetings very, very easily. I also think it's a good practice for closed meetings, for executive session, although there is the problem that an executive session that is recorded under the law currently could be become a public record and destroy the confidentiality of that personnel hearing, for example.
Right.
So one of our proposals in our bill to require executive sessions to be recorded would have been to make it clear that they are not public records unless ordered to be released by a court. So,
okay.
But certainly for public meetings that are open to the public, recording them is a good practice. They should be put on the internet. The technology is easy to use, it's inexpensive, and it's a great service to the people who elect that government.
I totally agree, since I use some of the Mount Vernon TV 10 stuff up in Skagit County.
Great. Good.
So I'll